So greetings all. So I'm Dr. K. Prathapchandran from Department of MCA. So Madanapalle Institute of Technology and Science, deemed to be university. Here I'm going to talk about the importance of intellectual property rights for academicians. There are a number of intellectual properties are there like patent, copyright, trademarks, geographical indications. I am among these. I'm going to talk about patent. So before going to discuss the topic, let's have a things what we are going to discuss. So first thing is I'm going to talk about the preliminaries in intellectual property rights, followed by patent, then finally conclusion and discussion. So this is the agenda of the today's session. So in the introduction, so intellectual property rights. So what is intellectual property rights? Nowadays our government of India are trying to protect our ideas, not only from the academicians, from everyone, right? So if we have an idea, we have to protect. So that's why if we protect our idea means, so no one can able to misuse our ideas. So in order to protect our ideas, intellectual property rights comes into exist. In intellectual property rights, with the help of intellectual property rights, we can able to protect our ideas, design, not only ideas, whatever comes from our mind, we can able to protect. Okay, so that the ideas belongs to us as soon as no one can able to take from us. Okay, so that is the benefit. That is the benefit of intellectual property rights. So before that, we should know about some basic things in intellectual property rights. So what is property, right? Generally, we know what you mean by property. So generally properties are the things are collection of things which are surrounded with us. So someone hold the property, or some other maybe hold the property, and simply noted that the properties belongs to us. Okay, so properties are classified into two major categories. One is tangible property, another one is intangible property. So tangible property again classified into two categories. One is movable and another one is immovable, right? So movable, we could say that our transport like a car, bike, right, anything. Okay, anything it can be movable, like that is comes under movable property. Whereas immovable property, we can say our house, our land. So these are all immovable property. Other than this, one property is there that is called intellectual property. It's simply the ideas or creativity comes to our mind. Okay, that is called intellectual property. So what is intellectual property? So intellectual property refers to the creation of the mind, such as inventions, literacy, and artist work, design, and symbols, and names, and images. It's simply denoting the idea of the creativity from our mind. Okay, not only creativity, if we are thinking something, anything new. Okay, it comes from our mind. So it is called intellectual property, right? So intellectual property is classified into various categories like copyrights, design, patent, geographical indication, and trademark. So I pointed out earlier. So in these sessions, I'm going to talk about patent. So what is patent? So the patent is a word. It is originally originated from the Latin, that is laid to open. That is, it become available to anyone for public inspection. That is called the patent. So it refers to the rights granted to anyone who invents something new, useful, and non-obvious. So it is a form of intellectual property that gives its owner to the legal rights to exclude from making, using, or selling an invention from a limited period of years, that is 20 years. So this is the definition of patent. So what are the benefits of getting a patent? Okay, being an academician, we should know. So what are the benefits? So the first one is, without our permission, okay, no one copy or manufacture or selling or selling our ideas, right? So that is one thing. So second one is, if you have an idea, means for someone want to hire your idea now, in that case you can rent it your idea for you can rent it your idea financially. Another one is, or else you can use it your idea for your own purpose. For example, you are going to start a new business. In that case, you can make use of your own idea. Then you can completely sell the patent to other companies also. So based on your idea, a company may may start their startup. Okay, the finally we with finally enhance our profile, right? So nowadays wherever you go for the people ask the people are asking how many patents you have filed or published, or how many patent you got granted, like that they are like that they are asking. So by the way, we can enhance our profile. So these are the benefits of getting a patent. The next, difference between patent and research papers. So nowadays, our faculty members are mainly focusing on the research articles rather than the patent. So what is the difference? What makes difference? The first one is research. So research paper nothing but it gives an idea of the work to others to do further research. This is called research article. Whereas patent, gives an authority to sell the product, that is called patent. And then to write a good publication, okay, if you want to write a good article or publication, you need a good theoretical concept. Okay, you should be knowledgeable in terms of theoretical, so then only you can go with the go with the writing research article. Whereas patent not like that. If you have a idea with the novelty and inventive steps, now you may go for a patent. And then research paper is discussion over your work done. So what you have done, so the discussion on your work, so it become a research paper. So whereas a patent, if you patent, that is your idea become a patented, you can, the patent can be product or it may be commercialized in future, right? So this is the difference between patent and research paper. So the next we are going to discuss about why academicians prefer publications over patents. There are n number of reasons are there. The first and foremost reason is lack of awareness, right? So lack of awareness about the procedure of patents. So nowadays we are able to write the research article, but at the same time we are lacking how to file a patent, how to draft a patent. Okay, that is the lack. Okay, that is the lack of awareness, right? Second thing is, so writing a patent is different from writing a paper. I pointed out just now. So also paper is a relatively quicker to publish and easier to write. For as we are academicians, we know if you write a research article now, it will get published within 1 year almost, right? So whereas is patent not like that, it will take nearly 4 to 5 years to get granted. So that's why most of the academicians are preferring publications over patent. And then third point is, yes, nowadays most of the Indian universities, educational institute, research institutes, they are giving much preference towards research publications, not patents. So this is also one of the drawback. So and I told you, it is a time consuming process. So then the cost of commercializing the technology is too big. Okay, because of these reasons, academicians are prefer publications over the patent. Next, so what can be patented? Okay, so actually we have we have an idea in our mind, but some things are there which to be patented, which not to be patented, like that. Okay, so here we will discuss what are the things we can able to we will get a patent. So an invention relating either to your product or process that is new, involving inventive steps and capable of industrial applications can be patented. So you can get a patent for your product or for your process, right? So in more generally, if you want to say now, for example, machine, for all the machine related products, you may get a patent. Okay, like a TV, mobile phones, printer, like that. Okay, all the machinery components, you may get a patent. Second one is process. So process nothing but process of making a chemical components. You are, for example, as you are coming from chemical background, in the sense you are going to process, you are going to create you are going to compose a new chemical related product. Now for those you can get a product. Okay, so for process you can get a product. Then third one is manufacturing articles like products, vehicles. Okay, for that you can go get patent. And composition of matters like shampoos and liquids which are using our day-to-day life, for those you can get a patent. The next, so what cannot be patented? Okay, so what cannot be patented? Actually, this is clearly mentioned our Indian Patent Act 1970, Section 3 and Section 4. Okay, in that act they are clearly mentioned that for certain kind of things we didn't get patent rights. Okay, the first thing is for mathematical or business program or computer programs, you won't get patent. Next, the method of performing mental act or playing games. For that also you won't get pattern. A presentation of information and a literacy, dramatic, musical work, artist work, and cinematographic work and television productions. So for these and all you won't get pattern. And also invention related to atomic energy and a method of agriculture and horticulture, already well established laws, a method of treatments and diagnostics, a topography of integrated circuits, and then a discovery of scientific principles, and then a arrangement of devices. So for these and all you didn't get patent. And next, so does Indian patent give production worldwide? Means the answer is absolutely no. Why? Because so in each and every country following their own methodology to obtain a patent. So there is no concept of global patent. So, but with the help of patent cooperation treaty, we can file an international patent. That is possible, right? So, as I told, there is no global patent. So each and every country followed their own patent in order to provide the patent. I mean, to provide the grants to the citizens, to their citizens. So the most important thing is, so what are the criteria of patentability? So I have an idea. So in which the idea must satisfy the following four conditions. Okay, so then only you may get a patent. So what are the ideas? The first one is it should be novel. It should be novel in the sense no one has ever done it before. Okay, it simply denotes the unique idea. That is the first step. Second step is it should have an inventive step. Okay, it should have an inventive step. For example, you are going to give a product related patent. Now that product related patent must have a proper inventive steps, that is non-obvious. And definitely it should have a capable of industrial applications, right? That is the third point. Industrial application, that means we developed some, we get grant patent, that patent should be useful to the society. Okay, it must. Okay, that is the third point. And fourth point is it's not comes under the provision of section 3 and 4 Patent Act 1970. So what we have discussed in the previous slide. Okay, so these are the 4 points to get a patent. The next, so what are the different types of applications? So basically there are 4 types of applications are there with respect to patent filing. The first one is professional application, second one is complete application, third one is conventional, and then fourth one is international application, right? So these are the 4 basic applications are there. The first one is professional application. That means you are having an idea but it's not in the implementation yet not over. In that case, if you do not want to lose your priority date, okay, so in that case you may go with the professional application, right? So second one is complete application. You are having the entire description of your patent, right? So in that case you may go with the complete application, right? And then convention application, when a patent applicant files the application for a patent claiming a priority date based on a similar application filed in conventional countries. In that case, you may go with the conventional application. The last one is international application. That means if you have an idea, if you want to file your idea in some other country, right? Some other country, I already mentioned that there is no global patent. Why? Because each and every country following their own procedure. For example, if I get a patent in India, the limitation of patent grant, I can get the benefits, I can access the benefits only within India, not in some other countries. Okay, in that case the same idea to be filed in some other country means you can go with the patent corporation treaty. With the help of this patent corporation treaty, you can file your patent in some other country. Okay, so these are the 4 different kind of applications with respect to patent filing. Next, who can apply for a patent? Okay, from the picture itself, you can easily understand. Okay, so first one is a patent application can be filed either by true or first inventor or his assignee, either alone or jointly with any other persons. Okay, so that is the first condition. Second thing, however, legal representatives of any these persons can also make an application for a patent. Okay, so who can apply for a patent? The first condition, the first inventor or a true inventor. Okay, so the person having their own idea. Okay, no one else did before. In that case, the person can apply for a patent, or they can go with the patent. The next one is, what are the timelines are to be adhered to while prosecuting a patent applications in India? So this is the filing. This is the time usually during the, time taken for filing and publishing and guarantee a patent in India. Okay. In simply, I can explain for this is the, for example, in the in the first 12, in the first 1 year, that we can file the complete application. Okay, it will take 1 year, right? So after that, you may go for publication. Well, once the patent is filed, next thing is you may go for publication. Okay, during that period, there is a chance for pre-grant opposition. That I will discuss. This part will be discussed in the next slide. Okay, what is pre-grant opposition, right? So after the 12-month of period, after the 8-month of period, you may go for publication. After the 48-month, you may go for request for examination, and then after the 54-month, the first exam report will be received based on your presentation. Okay, during the exams. After that, the patent granted. Okay, even if the patent is granted, there is a possibility for post grant opposition, right? So totally, if you want to file a patent in India, means nearly it will take 5 years 6 months. So this is the complete duration of filing patent in India, right? So now we will discuss what is grant for opposition. In the previous slide, I told in the previous slide, there is a possibilities of pre-grant opposition. That is, before getting grant, there is a possibility for pre-grant opposition. Then after granting, after grant also, post grant opposition is there. So what do you mean by grant opposition? So these are the possibilities for oppositions. That is, insufficient disclosure of the invention or method by which is to be performed. That is one reason. Then the application for patent was not made within 12 months from the date of the first application for protection for the invention made in a conventional country or in India, and then patent wrongfully obtained prior publications, and then the invention was publicly known and publicly used in India before the priority date of the claim, and then it is not patentable under Patent Act, and then the complete specification does not disclose or wrongly mention the source and geographical origin of biological material used for the invention. And the last, the invention is obvious but does not involve any inventive steps. So these are the reasons for for oppositions, ground for oppositions. This can be done before getting the patent as well as after getting the patent also. The next important topic is content of patent writing. So if you have an idea, okay, if you have an idea, but we should convert our idea into our paper format, okay, like our writing research article, right? So in that case, what are the components usually are involved in writing of patent? Okay, so the first one is title page. It's similar to the research article. First, we have to give the suitable title for our patent. Second thing is field of invention, that is, in which field you are going to invent your product. For example, being a computer science faculty, I could say that IoT, right? My field of invention is, for example, computer science. So I will develop some product with related to IoT. In the sense, I could say that my field of invention is computer science. Similarly, for example, mechanical engineering or there electrical engineering. Okay, so from which the particular invention will be made, that is called field of invention. And then third one is objects. right? Objects of invention is in it. What all the objects are involved? So that is called objects of invention, right? For example, again, I would say that, for example, I developed one product with based on IoT. In the sense, I could say that sensors, and then some electronical components, and then accelerometers. These are the things I could say that objects, right? So that is called objects of inventions. Then summary of the invention, similar to the abstract in our research article. It simply give the short description of our overall invention. That is called summary of invention. And then brief description of drawings. Not only theoretical, whatever we are going to represent, we have to represent in picture format also. That is in diagram format also. So we have to draw all the correspondence of the particular product or process. And then detailed description of the invention. We have to give not only summary, we have to elaborate our product in detailed way also. Then claims. This is the most important component in content of patent writing. Why? Because this is our actual proposed idea, that is called claims. Okay, so claims in the sense where our original idea is reflecting in this part, that is called claims. And then background of the invention and prior art. Background of the invention is nothing but what is the existing related work have done before this invention. So those parts can be discussed in the background of the invention. And then finally figures, and then abstract also. Okay, so this is the content of patent writing, right? So thank you so much for listening this video. So in this session, I just given introduction about a patent. In the upcoming sessions, I would like to give a more elaborate on how to write a patent in a better way. So thank you for the opportunity. Thank you.